Representative Newberry.
Thank you, Mr. Speaker. This is actually a very simple amendment. I'm not going to rehash the discussion we had earlier involving who has standing to sue, whether they can only sue the state or a private entity, et cetera. I think we can all agree there's a basis to bring a lawsuit here to enforce the statute. Now, part of that basis is to enforce whether or not a plan exists, but I think arguably it's also to enforce whether or not the plan complies with the mandates. And it's very conceivable you could have an executive branch that wants to slow play enforcement, wants to drag it out, does not want to actually comply with the mandate. So what happens when a lawsuit goes to court? The enforcement provision allows for a Superior Court judge to issue injunctive relief, mandamus, et cetera. I know not everyone here is a lawyer, but I think most people know that basically gives the trial judge immense powers. And I'll give you an analogy from a completely separate area, not climate change related, but it's a real analogy. In fact, there's a bill before this body, and I think it's been in for a couple of years, about making a right to education a constitutional right. There have been cases in federal courts in other parts of the country over the years in which judges have found various constitutional rights to education. And in fact, there was one relatively famous situation where a federal judge in Kansas City, Missouri, effectively ran the school district for a number of years. And if I recall the details, I may have this a little fuzzy, it goes back to the 90s. The judge actually found himself having the ability to compel the school district to raise taxes and so on. I don't like the enforcement provision at all, but that ship has apparently sailed with those amendments. But one thing I want to make sure is that if this chapter ends up in court, I do not want one Superior Court judge to have sole jurisdiction. For one thing, most of our Superior Court judges, however good they are as judges, are not experts in a lot of the areas that this bill tries to address. But for another thing, giving that much power potentially to one person is not a good idea. So if a lawsuit is brought under this chapter, I'd like to have it heard by a panel of 5 Superior Court judges appointed by the presiding justice of the Superior Court. I think it's precautionary. I think it makes sense. It'll give a broader perspective on something of, as we've been hearing tonight, is of immense importance to the states. That's all my amendment does.
Thank you. On the amendment, Leader Blazajewski.
Thank you, Mr. Speaker, members of the House. I rise in opposition to this amendment. There is zero precedent for this anywhere to have a panel of 5 Superior Court justices at the Superior Court level. But what there is a right of appeal in Rhode Island to a 5-member panel of the Rhode Island Supreme Court. So it isn't that there's one judge that has final rulings on everything. You have a right to appeal to the Rhode Island Supreme Court, and you get your panel review at that point. So without any precedent for this whatsoever, and with a panel review baked into our system, I urge defeat of this amendment. Thank you, Mr. Speaker.
Thank you. Representative Newberry.
I'm sorry, I wasn't planning to stand up, but my friend, Leader Blazajewski, knows full well. They're right, there's no precedent. That doesn't mean anything. We can set the precedent for this particular important issue. But putting that aside, and every lawyer in here knows what I'm talking about, there's a completely different procedure in a trial court than an appeals court. Something like this, injunctive relief, et cetera, calls for factual findings, hearings, testimony. There's often an abuse of discretion standard applied in the lower court. The lower court judge has immense power, hence the reason for my concern. All the Supreme Court can do is review certain things that meet the standards for review and under certain appellate standards. It is not at all the same thing to say that 5 judges in the Supreme Court is the same as 5 justices in the Superior Court. They're totally different, totally different. That is why I put the provision in, and that's why I think we should pass it. Thank you.